May it please your honor, my name is Anastasia Kolesnikova, and I appear with my learned junior, Miss Amylee Quirk, for the appellant in this matter. I will be submitting for the first and the second rounds of the appeal, and my learned junior will be submitting for the third and the fourth round. We will each talk for 10 minutes respectively.
Thank you. Proceed. Are you proceeding now? Are we proceeding with the appellant, or are we having,
They're doing their appearance.
There. Yes. I'm sorry. Thank you. Yes.
May it please the court, my name is Swan, S-W-A-N, initial B. I'm senior counsel for the respondent,
Yes.
Underwood, and I'll be speaking on grounds A and B in this appeal. My learned junior, Miss Amylee Breyer, will be speaking on grounds C and D in this appeal.
Thank you. May we start with the appellant's argument, please, and the senior counsel. Miss, I'm sorry, it's Miss Anastasia. Your surname?
Kolesnikova.
Kolesnikova. In this court, we are surnames, not our Christian names. Proceed.
May it please your honor, my client entered into sponsorship contract with the respondent. As a result, sales of Waters underwear steadily rose over the period. In the light of a few incidents, the respondent terminated the contract with my client.
Can you be more specific about the few incidents that you're referring to?
There was a private conversation which occurred on the court during the match, while my client was blaming his partner for their losing.
Yes.
And the second incident which occurred is my client afterwards made an emotional statement during the interview that he would go solo afterwards.
Yeah. These are more than just a few incidents, aren't they?
That depends from which side to look at.
Okay, let's hear your side. Proceed.
Waters Underwear claims that their appellant has reached the clause 2 concerning his behavior. There was a conversation which occurred between my client and the respondent concerning this clause particularly, which changes the perspective of this unreasonable claim. Even if this court does not take into account the advocated lenient approach in the case of State Railway Authority from New South Wales and Health Outdoor Property Limited reported in
Lenient approach, Ms. Kolesnikova, we're here to apply the law, not to be a court of mercy. I actually want to hear the law here. What's the doctrine in this case?
The doctrine is that while considering whether the extrinsic evidence should or should not be admitted, while determining whether the contract is wholly in writing or partly written, partly oral, the extrinsic evidence should be admitted.
Okay. All right. So extrinsic evidence, that's the principle here.
Yes.
That extrinsic evidence
We
should
are
be
claiming
admitted.
that.
How does it apply here?
Yes, it does apply here, but even if the court neglects the possible application, it goes to your owner's discretion, whether you do apply the lenient approach or whether you apply the strict approach. But even if this respective court applies the strict approach while using only intrinsic evidence, so the contract itself, it will become clear to the respective court that this contract.
Clarify for me. Cut to the chase. How does it affect your case?
You apply the strict approach. So the clause 2, which is stated to be breached by my client, is ambiguous.
Okay.
In this situation of ambiguity, it was stated in the case of Kodelka by Mason.
Oh, what was the clause 2 again? Just refresh my memory.
The clause 2 of the contract stated that my client has to behave as a brand ambassador.
He didn't, not a very good ambassador, is he? If he's appearing on videos and, making claims that he's losing because of his partner and.
Again, we are talking about the question of the law. The term behave as an ambassador is pretty ambiguous. It's definitely who in this courtroom can tell what does this term mean, behave as an ambassador. Probably the appellant can and the respondent can. It means that there were the prior negotiations, which made it clear for the both sides what does this term mean. Now I would like to talk about this statement, which
Okay.
actually clarifies the meaning of this ambiguous term. Mind you, you'll have to keep all of this off-court drama under wraps. The only misbehavior which my client is blamed for occurred on the court during the match while he was having private conversation with his partner in the corner of the court, toweling off his sweat. And by the way, the only evidence of this so-called misbehavior is the videotape, which was illegally in 4 jurisdictions obtained and published on the YouTube, which is actually illegal in all the jurisdictions of Australia.
Okay, all right, that's an interesting point. That wasn't clear to me from the facts, so that's illegally obtained.
Because it is a private conversation, and even though they were in the public place during the public event, private conversations still cannot be published. It is illegal in Australia.
So are you saying this is a violation of your client's privacy?
Definitely, and this is the only thing the respondent is relying on while claiming that my client has breached the clause 2. Moreover, tennis is a really stressful sport. To be claimed one of the most stressful sports at all, I have been playing big tennis for 8 years professionally. I know what does it stand for, and not all of the points in tennis are counted the same. Like there are championship points, set points.
Get to the point, counsel.
What I wanted to say is that emotional outbursts on the field, on the court, are natural. And as my client has promised to the respondent, that he will leave all of his emotions on the court. That's what he did.
Okay.
He did have an emotional outburst on the court, but he did not breach any of the implied or expressed term.
All right. Yeah.
The second issue I would like to raise is whether the term of the appellant playing only doubles tennis should be implied to the contract. The respondent is claiming that it should be implied in fact due to the necessity for the business efficacy and due to the obviousness of this term. We are simply...
Seems pretty clear to me. I mean, he was approached, to play doubles tennis.
But at the same time, Your Honor, he was approached, and everybody knows him as a doubles tennis player, but me as a professional tennis player for 8 years.
You're not part of this case under that. You're the advocate.
It's just like the whole experience of me playing big tennis professionally. We all are taught to play tennis as doubles and as single players at the same time. When you open Wikipedia page of any tennis player, there will be the table of their winnings and losses in both single tennis and in doubles tennis. So there is actually no such thing as just solo player or just doubles player, because tennis is tennis.
So you're saying industry practice here is that doubles imply singles and singles imply doubles.
Yes, tennis is tennis, and actually now I'm quoting Guillermo Garcia Lopez, who stated that he's the world-known professional tennis player. He stated that everybody was playing on the both sides of the point because tennis is tennis.
Well, that's good authority in the world of tennis, but this is a court of law. So is there any authority that will allow me to take judicial notice of this tennis expert to allow this in?
I would ask Your Honor to rely on the policy arguments in this question, as it really considers the real life situation of tennis and the tennis authorities and the authorities of the companies which were sponsoring other tennis players should be considered. Yeah. Moreover, even if this term could be possibly implied in fact, let's assume it is.
Okay.
My client actually has not performed the actual breach. He just made an emotional statement during the interview that he is looking through the options of playing solo. This gives the right only for the anticipatory breach.
Okay, tell me about that. Remind me about that.
The anticipatory breach simply occurs when one of the parties to the contract states that he cannot or is not willing to perform all of his obligations under the contract.
Okay.
And for anticipatory breach, which was inferred in this case by his words, it must be clear and it has to be directed to the other party, as it was stated in the Foster case. Mr. Sirius, my client, did not communicate his desire to any representative of the company. So the requirement, the basic requirement of the anticipatory breach to be communicated directly to the party is not satisfied here.
Okay.
So it can't be claimed as anticipatory breach. And moreover, as it was held by the court in case Progressive Mailing House, anticipatory breach or repudiation much clearly deprived the aggrieved party from all the benefits they can acquire under the contract. As it has stated above, there are no clear evidence of any financial losses for the company if my client declares him plain sold.
Okay. I'm conscious of the time and your colleague needs to present as well. Can you summarize your arguments?
My first argument is that my client did not simply breach the clause 2 because it concerned his behavior off the court. He can be blamed for the misbehavior on the court, which did not include, was simply not included into the contract. And moreover, the implied term of him playing only doubles tennis, even if it can possibly be implied, was not breached, none of the real breach or anticipatory breach actually occurred.
Thank you very much.
Thank you, Your Honor.
Bailiff, are we hearing the junior counsel now, or do we go to
The junior counsel.
junior counsel? Thank you. Junior counsel can approach the bench, please, and address the court.
If it pleases the court,
It does. Proceed.
I will firstly submit that the
Your
breach.
name.
My name is
Again.
Quirk, Q-I-R-K, initial A.
Thank you.
I firstly submit that clause 2 was not breached with sufficient severity to give Waters Underwear the right to terminate the contract. The issue here is what exactly is the word behave. There is no clarification or specification in the contract to detail what the word behave entails. There is no guidance as to what Waters Underwear regards as appropriate or inappropriate behaviour in accordance with the promotion of their brand. Based on this, how does one measure when a term has been breached, let alone when the breach is with sufficient severity to render the contract terminated? The rule of
Surely there are objective tests, though, that what a reasonable person would, think is, constitutes good behavior, bad behavior, behaving like a good ambassador.
Yes, definitely. But in this contract, there is nothing to state what Waters Underwear regards as appropriate behaviour.
Yeah, but can we then turn to some sort of objective test?
We could use the reasonable person test, yes, but then we need to take into account the issue of anger and frustration in the moment when the statements were made on court.
So this goes to the issue that you're calling with.
Yes, they do.
Yeah, proceed.
The rule of certainty dictates that a term in an agreement must be complete and certain. As found in Group Rail Services Limited and Rail Corporation New South Wales 2009, heard in the New South Wales Court of Appeal at 177, it must be possible to identify the rights and obligations of the parties. If a term is too vague for the court to determine its meaning, then the agreement cannot be
What was
enforced.
the vagueness there in that case?
In Group Rail Services, I'm sorry, Your Honour, I cannot explain that to you at this point in time. I was just using this.
This basic decontextualized principle that I'm
Yeah.
supposed to pick up and that it has no content whatsoever.
I was referring to the principle of rights and obligations needing to be clearly
Okay.
identified to be enforced.
Yeah, proceed.
I will now contend the actual actions of Rick Sirius. What exactly did he do to trigger Waters Underwear into believing that he breached clause 2 of the agreement with sufficient severity to render it terminated? He was filmed having a conversation with his partner on the court. He didn't throw his racket, he didn't touch anyone, he didn't even yell.
So he didn't commit an assault in that's quite a low threshold of good behavior,
Yes.
isn't it?
Well, that's going back to what you were mentioning earlier with the reasonable person test.
Yeah. I mean, this is, he has been asked to be a good ambassador here in the contract. I mean, that can include something more than, continue.
Okay. Nick Kyrgios of Australia lost to Italian Andrea Seppi in the 2017 Australian Open at Melbourne, and he threw his racket on the ground in anger. However, other than an actual boost in publicity, he did not receive any sponsor-related backlash in saying he didn't lose any sponsors, which is what Waters Underwear is trying to do here to my client group.
Yeah, and how is this relevant?
It's just an example of another professional tennis player losing his temper on court and doing an action that could be regarded as misbehaving, and it's showing that my
There's
life.
no damage.
Yeah, there was no damage.
Okay,
Yeah.
thank you. Proceed.
I will now address the second part of this issue, in that the implied term to only play doubles tennis was not a condition that went to the root of the contract. So Waters Underwear does not have a right to terminate the contract here either. As found in Bryan and Australian Airlines Limited in 1995 Commonwealth Law Report at 411, an implied term is one that the parties have not stated but agreed to. And they're essentially based on the intention of the parties. According to BP Refinery Proprietary Limited and Hastings Shire Council 1977, Commonwealth Law Reports 180 at 266, one of the elements that is needed to satisfy an implied term is that the term must be necessary to give business efficacy to the contract, so that without it, the contract wouldn't work.
Surely here the term is necessary.
Well, actually, that's what I'm going to present next, Your Honour, that to play doubles tennis, it's not actually necessary to give business, because the contract still works if Rick plays solo. As my learned colleague mentioned earlier, tennis is tennis, and there's lots and lots of partnership brands, such as, for example, Calvin Klein, that release, say, underwear sets, also like Waters Underwear, in couples or his and hers sets, but they are still seen to sponsor major Australian athletes like Eamon Sullivan, actually, and he's a solo athlete, obviously.
Continue.
Okay, so my point here is that the contract will still work if Rick plays solo tennis. Playing doubles is not necessary to give business efficacy to the contract.
I mean, that is an assertion, but, rather than an argument. I mean, surely they really bargained for, W really bargained for a doubles player,
Yes.
that they wanted to partner with their doubles player, Hugh. Surely this underlies the contract here. This is precisely what the bargain was about.
Yes, they did target a doubles player, but that is not the point of that breach. So that was saying that that we needed him to play doubles tennis to give business efficacy to the contract, for it to be an implied term. And what we were saying there, or what we were contending there, is that playing doubles tennis is not necessary to give business efficacy to the contract. The contract will still work. He'll still be able to play tennis. He can still be sponsored by Waters Underwear if he's playing as a solo athlete.
So ultimately, it's you're basing your argument here. The industry practice is, and this is what your colleague was saying before, was tennis is tennis.
Yes, exactly.
The doubles, solo, it's all a part of the same continuum.
Yeah, promotion is promotion.
And the industry says that, really. That's anyone within the industry would know this.
Yes, absolutely.
Okay, great. All right, go on.
My final issue, Your Honour, is the concept of estoppel.
Yes, explain to me what that is again. I'm just a criminal lawyer again.
Estoppel is basically to prevent the representative who is promising something from going back on their word or going back on their representation or denying it. Waters Underwear is stopped from denying Rick his bonus, which is set out in Clause 1. Rick was induced into the contract based on the assumption that he would receive this bonus. Rick relied on the bonus when agreeing to the contract, which eventuated in his detriment.
Well, the bonus now was eligible for a bonus, which was at WU's discretion. So, I mean, it is their discretion whether to grant a bonus.
Yes.
So why would they be stopped here in this case?
There were several actions that Waters Underwear undertook that gave the implication to Rick that he was likely to receive the bonus.
Like what?
For example, when they were out for drinks later that night, and Waters Underwear stated to Rick that he was in for a big surprise.
Well,
Coming from a sponsor, what else would a surprise be?
termination.
Yes,
We're
but
not
that's
happy
what
with what you be doing. You know, we saw the video, you know.
But nothing else had been said in relation
Okay,
to this negative action, so there was nothing to imply that it wouldn't be a positive surprise.
okay, right, all right.
Also later that night, Waters Underwear allowed Rick to pick up the $8,000 bill, giving the indication that he would be able to afford
Did they
it.
allow it or did he insist upon it?
He did not insist.
Well, did it come, if Rick thought this was referring to the contract bonus and decided he could pick up the check for the night, didn't he initiate this?
He did, but Waters Underwear allowed it to happen. They
Okay,
didn't give any indication that he might not be able to afford it.
so are you saying there should be a positive duty on them to actually advise him that, you know?
No, I'm not saying that. I'm simply saying that this is another thing that could contribute to Rick believing that he was entitled to the bonus.
Thank you, yes, continue.
So in summary, we contend that clause 2 was not breached. The implied term was not implied in fact, custom or law, and even if it had been, the supposed anticipatory breach did not occur. And also, Waters Underwear is stopped from denying Rick his bonus due to these reasons. WU is not able to terminate the contract. If there are no further questions, Your Honour, this will conclude my submission.
No, there are no further questions, thank you.
Thank you.
Thank you, counsel. Yeah. Yes, sir, may we hear from you? And it's Mr. Swan.
Yes, Your Honour.
Counsel, senior counsel for the respondent. Yes, you may present your argument to the court.
Your Honour, it is here that I would like to turn my first grant review, namely that, based on the agreed facts, the conversation held between my client and Mr. Sirios should be excluded by the parole evidence rule.
Oh, please, can we give me a quick tutorial on the parole evidence rule, Mr. Swan? Is that quick?
Certainly, Your Honour. In Goss Lord Mooting, in 1833, heard in the House of Lords, the court stated if there be a contract which has been reduced into writing, verbal evidence is not allowed to be given of what passed between the parties, either before the written document was made or during the time that it was in a state of preparation, so as to add to or to subtract from or in any manner to vary or qualify the written document. What this means, in more simplified form,
Yes, please, it's late, simplify it for me, Mr. Swan.
certainly.
Do it now.
The parole evidence rule prevents extrinsic evidence being given to add to, vary, or contradict the terms of a contract as they appear in a written document, and the rule limits the evidence that can be given to explain the meaning of the terms of a written contract.
Okay, let's cut to the chase now. How does it apply to the fact situation here?
Your Honour, if you turn to the case of Marston and Holmes Proprietary Limited and Palm Assets, in 2009,
How about the facts here?
the facts of Palm Assets, Your Honour.
No, the facts here, the seriously. WU.
Certainly, Your Honour. If we turned, well, before I proceed, Your Honour, may I present full case citations?
Okay, yes, I'll allow that.
We would submit to the court that, on the basis of Marston and Holmes, that the contract is wholly in writing. Thus, the parole evidence rule should apply in full and all extrinsic evidence, namely the conversation that took place between my client and Mr. Sirios, should be excluded in contract insurance. Your Honour's, one case I would ask the court to look to is Cadell for Constructions, where, although the facts are distinguishable, I know the court held the true ruling is that evidence of surrounding circumstances is admissible to assist in the interpretation of the contract.
What conversation are you trying to exclude here? There have been a number of conversations in the fact patterns.
Your Honour, at the current point, I'm referring to section 4 of the agreed facts, where my client and Mr. Sirios discussed at the pub, their conversation at the pub.
Okay, good.
Okay. So, Your Honour, we would continue with what I would like to continue with what I was saying with regards to Cadell. The facts are distinguishable. However, the surrounding circumstances may be admissible. to assist in the interpretation of the contract if the language is ambiguous or susceptible of more than one meaning. We would therefore submit that clause 2 in full states that Mr. Sirius agrees to behave in accordance with his role as an ambassador of WU. We must further, due to this, we must further agree with the learned Justice Labour, where the court concluded that the contract is complete on its face. Because the contract is complete on its face and wholly in writing, we would turn the court's attention to the strange prerogative. Here, the High Court held that the plaintiff, having put her signature on the document and not having been induced to do so by any fraud or misrepresentation, cannot be heard to say that she is not bound by the terms of the document. Furthermore, we would ask the court to refer to Equicorp and Glengar, also heard in the High Court of Australia. The facts of this case suggest that the written loan contract was executed, where the plaintiff sought to argue that an oral agreement prior to the contract should supersede that of the written contract. The court here held that if there was an earlier oral consensus, it was discharged and the parties' agreement recorded in writing and executed. Your Honour, it is upon these facts that we submit the parole evidence rule has no scope to apply, and thus Mr. Sirius is bound in full by clause 2 for both on and off-court conduct.
And what does actually that mean?
Your Honour, what?
What sort of standards of court conduct is applied in or court?
Your Honour, certainly. So we would submit that the conduct that Mr. Sirius has displayed is certainly not in line with what is underway, as I will be addressing further in my submission with regards to the implied term. Particularly, we would submit that it is not.
So are there any directions, any sort of conditions, any list of behaviors that are itemized under the contract that would give content to what behavior in accordance with his role as ambassador of WU?
Certainly, Your Honour. So one would, upon the facts, there is nothing specific stating what his role as an ambassador is. We do note that. However, we are submitting that it would be incorrect for this court to apply. It would be incorrect for this court to think that conduct like that is acceptable under a sponsorship agreement for a partnership agreement. Is Your Honour satisfied?
No, I'm not. Why? Why should I accept that?
Sure, certainly, Your Honour. So we would so
this is a court of law, not business. So this is not about management principles or franchising or I need to hear principles and I need to hear some rules here.
Certainly, right. So if I could turn your attention, you're after judicial authority, is that correct? Right?
Yes.
Yes.
Yeah.
Certainly, right. I would turn you to the case of. If I could turn you to the case initially, I would like to begin this with our BP requirement. If Your Honour allows, I would like to begin my submission on the implied term of the contract in order to answer your question.
Okay. Yes.
So
let's turn to that.
So before I proceed any further, my second submission surrounds the fact that there is an implied term of the contract that Mr. Sirius would only play devil's tennis. We do submit that this implied term is required to give business efficacy to the contract. The tested BP refinery exudes with reference to the intentions of the parties that the implied term, firstly, it must be reasonable and equitable. It must be necessary to give business efficacy to the contract so that no term will be implied if the contract is effected without it. It must be so obvious that it goes without saying. It must be capable of clear expression. And it must not contradict any express term of the contract. Your Honour, my submission surrounds the second and third requirements and their specific application to the facts that Mr. Sirius, his intention and my client's intention was that he may only play doubles tennis. Point one of the agreed facts, I note that part of Mr. Sirius's allure was his unconventional decision to only play doubles tennis, where throughout the entirety of his career, he has stated, I'll be a doubles player for life. It is here I would ask the court to look to the case of Sakasuki Riblock, Australia, and Rockland. Here, the court held the necessity to give business efficacy contemplates a term needed in order to make the agreement work.
Okay. What counsel about the argument that opposing counsel have raised that in terms of industry practice, whether it's doubles or singles, it's all tennis.
Certainly right. So I would turn I would ask the court to look to a judicial authority for that statement of the appellant's initiative. Furthermore,
Well, the turn to industry practice is something that we can do, and often courts take cognizance of.
so
You know, so why should I ignore that? Why should I ignore industry practice or industry standards?
Your Honour, as you have stipulated, and as we would agree with you, this is a court of law, and we need to be looking to judicial authority, not to industry practice.
Okay.
Is Your Honour satisfied with that?
Well, yes. Okay. So continue.
So, in light of these past facts, particularly that Mr. Sirius has only ever played doubles tennis, while also making what can be assumed to be public representations about his loyalty to only play doubles tennis, it is only fair to state that the implied term that Mr. Sirius plays doubles tennis completely goes without saying. Furthermore, although I previously submitted that extrinsic evidence of the conversation at the pub should not apply, we would ask the court to look favourably upon implying this term of doubles tennis in light of the agreed facts at point 4. I will then ask the bench to look to the quote. Water talks Greek inter-returning to the doubles tennis scene under WU's exclusive sponsorship agreement. Albeit I have submitted that extrinsic evidence will not apply, we would merely ask the court to bear in mind that this conversation may, if the court pleases, have some effect on implying a term of this nature. A further case that is analogous is the Moot. The facts of this case stipulate that the contract was entered into between two parties for a ship owner to discharge and load a vessel at a jetty owner's wharf. The vessel eventually suffered damage as a result of the boat resting on a ridge of hard ground beneath the mud, where the court held the jetty owners were in breach of